To start with, the language in the phrase presumption of innocence can be misleading. As you'll hear, I prefer to think in terms of the accusatorial principle, the accusatorial mode of trial, for reasons which include that contemplating any alternative leads you to such horrors as the exculpatory principle or the exculpatory mode of trial, where an accused person would have to demonstrate that they are not guilty. The accusatorial mode of trial, that which is required by the so-called presumption of innocence, has two aspects which in principle are likely to survive, I think, even the worst kind of legislative fiddling. The first is that it's for the prosecution, call me old-fashioned, the Crown, if you like, to prove beyond reasonable doubt the guilt of the accused, demonstrating all the elements of the offence necessary to make out guilt. The second is, I think, socially inseparable from the first, but alas, maybe not legally and maybe not constitutionally. The second aspect is that the accused person is under no obligation or will suffer no penalty if he or she does not assist the prosecution or Crown in making out that guilt. You've all heard, I'm sure, about the privilege against self-incrimination and the misleadingly entitled right of silence. They are phrases designed to conjure up the significance in substance for the accusatorial principle, the presumption of innocence, that the accused person cannot be forced on pain of penalty to incriminate themselves. Now, why do I say in particular I prefer the accusatorial principle? It is because it focuses on the responsibility of the state, the mightiest force in our country and likely to remain so, in its contest against an individual in relation to criminal guilt. Criminal guilt, as we all know, presaging in these days the possibility of serving the rest of your life in prison, an exceptional outcome, but one which we've worked our way back through successive so-called law and order auction elections. It is, I suppose, a grim relief that we don't have capital punishment anymore. It suffices to say that a criminal trial is in every sense a high-stake enterprise. And in that enterprise, there must be clarity. And the clarity of the accusatorial principle is one which ought not to be to any degree obscured by legislative fixes. In particular, a legislative fix for a perceived mischief that not enough accused people are being convicted is one that is, I find, very troubling. If there were a deficiency in the investigative work of the police, if there were, quite incredibly, an institutional weakness in the calibre of our prosecutors, or if there were, even less credibly, mass stupidity on the part of jurors, then one might consider that low conviction rates were something that needed repair. But in each of those cases, it would be by fixing the police, improving the prosecutors, and educating the jurors, not fiddling, or worse, radically altering the way in which the prosecution has to prove the case against an accused. It may well be, of course, that we've become used to too high standard being applied by prosecutors in choosing the cases to go to trial. And if you do that, of course, you may get used over a while to relatively high conviction rates in certain brackets of offences. But if, as I do, you think that there may have been excess in the direction of prosecutorial caution, then it would be no bad thing at all for more people to be tried notwithstanding, their conviction can't be seen advanced to be a foregone conclusion. If that were so, one might naturally expect conviction rates to decline by reference to the population of people tried. On the other hand, you may also see conviction rates go up by reference to the population of people suspected of committing offences. It's for those reasons, it seems to me, that we need to unpack some of the fundamentals of the presumption of innocence. The first thing, of course, is that it is an expression, presumption, which is used in a technical sense. To be equally technical, it casts an onus of proof. It states the way things lie at the beginning of a case, that it is for the prosecution to prove the case from the beginning to the end. Now, like many round generalities in the law, that last needs half a page worth of footnotes. I'm not going to give you that many, but let me identify some reasons for us to be less than enthusiastic about two bald and round statements of what the presumption of innocence may mean. It emphatically does not mean that all accuseds are equal, regardless of the offence for which they're being tried or the position that they regard themselves as being in relation to the facts. It doesn't mean that they're all equal. Because a moment's thought about some of the so-called defences that the common law was concerned to ensure would exist in criminal law, and which statute law have taken up and elaborated, will tell you that not all accuseds are equal. Let me give you an example. There are many offences where an element may simply be a fact, such as the victim was less than a certain age. Traditionally, the common law, at least over the last 150 years, found its way by fairly sure sequence of steps to elaborating a common law defence, so-called, misleadingly so-called, whereby if an accused could show that there had been a reasonable mistake committed by him or her about, say, the age of the victim, then there could not be a conviction. But that has to be unpacked, because at common law, these so-called defences are not matters that it is for the accused to prove, let alone, of course, beyond reasonable doubt. That would be absurd. Indeed, when talking about honest and reasonable mistake, or as it's probably better called, simply reasonable mistake, in one of the leading cases, the High Court, Chief Justice Gleeson, Justices Gummo, Crennan and Kiefel, said in CTM back in 2008 that the description in the classic 19th century cases as being a defence long preceded the famous 1935 decision of the House of Lords, which has enshrined the unfortunate figure of speech golden thread for the accusatorial principle and the principle of the presumption of innocence. As the judges said in the High Court, questions of onus and standard of proof now need to be considered in light of later developments in the law, and references to arguments raised on behalf of the accused at a criminal trial as a defence or a ground of exculpation may be harmless enough if they do not preempt questions of onus of proof. If they do not preempt questions of onus of proof. The judges then disarmingly went on to say, people, I'm not quite sure whether they were including themselves, understandably feel the need to call them something. And the adversarial setting of a trial leads judges and practitioners sometimes to refer to any point relied upon by an accused as a defence. Of course, as they went on to discuss in that case, not originally, but authoritatively, it is for the defence to discharge what is sometimes called an evidential burden, I'm afraid a technical term, but one that means a burden of proof which does not involve proof on any of the standards of proof, namely balance of probabilities or beyond reasonable doubt. It means raising a matter in the jargon fit to go to the jury. And the significance of the way in which the High Court warned that language such as a defence being raised by the accused should not preempt matters of the onus of proof is made out by the common law's insistence that once an accused has raised such a matter, then it is for the Crown to prove guilt beyond reasonable doubt, including negativing, in that case, the operation of a reasonable mistake. Of course, not all accused are equal, because if it's mistake, then a state of mind is in question, and it's difficult to the point of impossibility to prove a state of mind without calling the accused. So the so-called right of silence could only be exercised in such a case by probably kissing goodbye to the so-called defence of reasonable mistake. The presumption of innocence, in other words, would still operate in such a case, but if the answer is, I didn't know that the victim was less than 15, say, and I had reasons to make that a justifiable ignorance, more than, for example, I didn't bother to ask or I didn't look carefully at her, then, obviously enough, that accused is very different from the accused to a burglary, for example, who need not get in the box at all. I had a client once on appeal, he was my client, who had shot his friend in the forehead at point blank range. The jury did not have accident left to them, meaning the jury were not directed by the judge that they had to be satisfied that the Crown's evidence had excluded beyond a reasonable doubt accident as an explanation of the killing. The appeal in the High Court was allowed. It went back to the jury. I didn't appear before the second jury, and the second jury acquitted. Now that was a case where the client had to raise the question of accident, had to point to circumstances sufficiently robust, not proving anything, but point to circumstances that made it proper for the jury to have before them as an issue for their determination whether accident was the explanation. Not that they had to be satisfied of that, but rather they had to be satisfied of murder beyond reasonable doubt, which necessarily would eliminate accident. So that's how it can work in practice. And you can see in those cases how not all accuseds are equal. The accused who wants to raise accident for a shooting killing may only need to call a firearms expert to refer to problems with the trigger mechanism, for example. That might be taking a risk, but at least that's viable. The person who says, I did not know the age of my victim is, of course, in a much different position. So it must never be thought that the presumption of innocence is the same as so-called right to silence, any more than that phrase right to silence should be understood as being, in any sense, a legal right. It is an immunity from being compelled to testify against yourself. It is a guarantee that the jury will be directed that it is for the Crown to prove the case. But it is not a right in the sense you can wield it against anyone, and it won't get you anything in a case where, of course, your silence speaks volumes to the jury. And that's, in practice, something which rather detracts from the grandeur of the presumption of innocence. Believe me, not all cases can be guaranteed to proceed on the basis that language such as the presumption of innocence, reminders such as that it is for the Crown to prove the case, will nonetheless spare defence counsel in particular the impossible dilemma of whether to advise your accused client to give evidence or not. And no doubt there's a dilemma for the accused as well. It's just that one hopes that for one's client it's the only time, whereas if you're defence counsel, it'll be many times. And in that dilemma, it has to be understood that the presumption of innocence plays very little role in evaluating the forensic contest if you're trying to win the argument as to whether or not you should advise your client to give evidence and be cross-examined by the prosecutor. And why I say that is that it's all very well and correctly to hope that the jury will obey the trial judge's directions, as they usually do. But without the evidence from the accused, there are some arguments that can be very difficult to appear sufficiently concrete as to give rise to a reasonable doubt the jury must feel. Now, in my experience, that aspect of matters also plays out at the appellate level. There is another inequality between some accused people or some convicts, that is, after they've lost their trial. Those who've given evidence have, of course, the invidious task on appeal of trying to argue that the jury must have felt a reasonable doubt, notwithstanding the jury had before them and was invited to consider carefully the evidence given by witnesses for the Crown as well as witnesses for the defence, including the accused himself or herself. That's a very different task from appearing in appeal where the accused does not give evidence and where, in effect, no one can impute to the jury a dim view of the credibility of the accused as a witness. So the presumption of innocence will have long played out by the time one reaches an appeal, but it does not mean, of course, that onus of proof and standard of proof have disappeared. They're the engine room of the trial. That brings me to some closing remarks, which are utterly different from those practical aspects, in my experience at least, of how significant, basally important, the presumption of innocence is in any decent system of justice. Unfortunately, both politically and socially, in everyday language, people, many of them lawyers, so I'm not blaming so-called laymen for this, speak of the presumption of innocence as if it means somehow that at the time of speaking, that is, before an accused has been convicted, the person actually is innocent. Or, if you like, and dress it up as a technical sense, the person is not guilty. If that simply means that he or she hasn't yet had pronounced a verdict of guilty and thereafter a conviction entered, so much is true but trivial. But what I'm concerned about is a social usage of the language to suggest that the presumption of innocence somehow means temporarily, particularly at the time it's being talked about, as if somebody is in fact innocent. For the following reasons, I think that would be a terrible thing for us to continue. We must be much more careful about the language and thought that we employ when we understand that some person enjoys the presumption of innocence. Speaking for myself, as someone who, as president of the bar, had responsibility for our professional rules, I'm very concerned about what I'll call the responsible use of court process, the rather stitched up title I chose for those part of the rules. By that I mean that when we, counsel, in and for court, make statements for the purposes of a court proceeding, then we get absolute privilege. We can't be sued, but we can be disciplined. We could even be struck off, as some have been. If they abuse that privilege, if they allow court process to be employed for improper purposes, bearing in mind how harmful it can be. And so, when a Crown prosecutor signs an indictment, that is, the formal document alleging that a person has committed an offence, a very serious statement to make about anybody, I hope, and so far in my experience, I'm utterly confident I've never been disappointed and never will be disappointed, I hope that the Crown Prosecutor has considered hard for himself or herself whether that is justified, whether there is sufficient evidence to make it proper to engage the awful process of a criminal trial and all the power of the state against an individual to allege the commission of an offence which may well see him or her sent to prison upon conviction for life. So of course that person has the presumption of innocence. But what a terrible thing if we thought that everybody was thereby compelled to regard them as innocent. The prosecutor mustn't. That would be appalling. I hope the police who investigate and put the brief together for the prosecution don't think so either. That would be appalling. In short, presumption of innocence involves an open mind about the outcome of a trial, but not the magical thinking that says that until a person is convicted, they were innocent. They should never have been tried if serious and responsible people didn't think with a high degree of conviction that they were in fact guilty. Because guilt of a crime in our society, at least, is only ever of conduct which was criminal at the time it was committed. And you've been guilty, as a matter of English, since you've committed the offence. And so I would very much like to see presumption of innocence understood as being a cardinal principle of the fairness and propriety and decency of a criminal system that calls for accusations to be made good rather than defences to be demonstrated. But I would very much like it to be banished from discourse concerning people who are the objects of criminal process. They are presumed innocent. It doesn't mean they are innocent. Thank you.